Well, good afternoon to all the participants who are joining at a great rate. I understand that more than 570 people have signed up for this flagship event from Keating Chambers. This is the first of two parts for our annual energy seminar. So there's today, which will be a 1.5 hour session, and there's another one on the 24th of February. And I'll remind you of this at the end, but you can start signing up for that by the end of this week. And this particular event this afternoon has three exceptionally talented energy speakers. We've got starting with Veronique Buehrlen QC on the 2020 energy case update. And then we go to Paul Buckingham on good faith obligations in energy contracts. And finally, Sean Wilken's QC on future trends in energy claims. So that's a wide-ranging and absolutely fascinating set of talks that are about to begin. And I've mentioned that our first speaker is Veronique Buehrlen. So let me introduce her. Veronique has a very wide-ranging commercial litigation and international arbitration and advisory practice. And her special interest is complex energy disputes, construction and engineering. And of course, they're all very closely related. When I was doing my research to find out what the directories say about Veronique, I discovered that she's noted for meticulous preparation, for ferocious cross-examination. She's said to be incredibly intelligent, and she's a tenacious advocate and a fair-minded arbitrator. She's got an amazing track record. She's been a deputy High Court judge since May of 2017. And of course, besides being counsel, she sits as an arbitrator. And of course, as an arbitrator, sits all over the world doing energy and associated cases. So without more ado, I now pass you on to Veronique, and she'll tell you all about the 2020 cases on energy. Over to Veronique.
Robert, thank you for that introduction. Now, first and foremost, I'm going to try and share my screen. So I hope I get that right. There we go. I should now be sharing my screen. Now, my aim is to give you a synopsis of the case law that's emanated from the courts in the energy field in 2020. Now, unlike most years, we've got an unusually high number of cases in 2020. In fact, 5 cases, 2 Court of Appeal judgments and 3 first instance decisions. Now, the cases are mostly concerned with oil and gas contracts, save for the Gwynt case, which, as its name suggests, was concerned with a wind farm and more particularly with the interpretation of an indemnity provision in a share purchase agreement. Now, I'm going to touch on the 2 Court of Appeal cases first, before I suspect cantering through the first instance decisions and concluding by taking a look at what we can take from the recent case law. Now, I think that the first point to note is that the cases are all primarily concerned with contract interpretation. They illustrate the practical application of the principles of contract interpretation that we have seen firmly established in cases such as Arnold and Britton and Wood. Now, the first case I'm going to refer to is the Teesside gas transportation against Cat's North Sea case, which is a judgment of the Court of Appeal. Now, I think it's worth making this aside in relation to the Teesside case. This is a case that was heard remotely on the 24th and the 25th of March 2020, with a judgment handed down by the Court of Appeal on the 7th of April of 2020. And it is self-evidently a very, very good example of just how quickly our civil court system adapted to the consequences of the pandemic. Now, I have to admit that you need to read this case with either a wet towel over your head or a very large gin and tonic to hand, because I'm afraid that it is a touch turgid. The case concerns the amount payable by Teesside, or TGTL, as it's referred to in the judgment, for the right to use part of the capacity of the CATS-owned pipeline for the transportation of North Sea gas. Now, the capacity reservation and transportation agreement dated back to 1990. And for the first 20 years of the arrangement, TGTL paid a fixed fee for the gas, for the transport of the gas. But for the last 5 years of the agreement, from October 2013 onwards, TGTL was required to pay what was called a capacity fee. And that is a fee that was based on the operation of a cost-sharing formula. Now, I should explain that the pipeline was used not only by TGTL, but by other third-party shippers of gas. Now, the key issue on appeal was the interpretation of the phrase CATS capacity as part of the formula for calculating the capacity fee payable by TGTL from 2013 onwards. Now, more particularly, the question was whether the capacity figure for each of the third-party shippers involved was to be based on the maximum rate of delivery by that shipper over the whole period of its contract with the CATS parties, with the owners of the pipeline, or whether a figure known as the daily reserved capacity rate, that is a figure agreed from time to time between the CATS parties and the third-party shippers, was appropriate. And you can see just from that short summary of the case why it is that you might need quite a large gin and tonic to get through it. Now, in other words, the big question was whether the cost-sharing formula was intended to operate on the basis of historical capacity figures or on the basis of up-to-date usage figures. Now, Lord Justice Mayles undertook the exercise of contract interpretation required, and he looked first at the language of clause 4.6, and he decided that the language wasn't decisive either way. He then looked at other relevant provisions of the agreement to see what light these might shed on the concept of CATS capacity. He then looked at the overall structure of the agreement's payment provisions, including the fact that the transportation fee was high at the outset of the agreement and later reduced. He then looked at the factual matrix, and in particular, he took into account the fact that the parties would have known that gas fields deplete over time. So construing the term CATS capacity by reference to usage of the pipeline in the early years would inevitably produce distorted figures for cost sharing at a later date. And then finally, Lord Justice Mayles looked at commercial common sense, asking what the parties could sensibly be expected to have agreed. And he concluded that the CATS parties' construction made far better commercial sense. Now, personally, I think this is a fantastic judgment, because although it is turgid, you can see through the entire judgment the practical application of the process of contract interpretation. The second case is also a Court of Appeal case. It's Apache North Sea against Euroil exploration, and it's the judgment of Lord Justice Carr. Now, this is a dispute that arose out of the interaction between a farm-out agreement and a joint operating agreement. Now, for those of you in the audience who are not familiar with these types of agreement, just very briefly, a farm-out agreement is basically an agreement by which A agrees to transfer a share of his interest in a concession or a license to B, in exchange for B agreeing to undertake or share in the exploration or the production costs. Then in turn, where there are several participants or joint venturers involved in the exploitation of a concession or a license, those joint venturers will usually regulate their relationship through what we call a joint operating agreement, or a JOA. And under that agreement, one of the owners, so to speak, will be appointed, usually it'll be one of the owners, will be appointed as the operator. Now, in this case, Apache entered into a farm-out agreement with EEL for the sale of a minority interest in 2 UK continental shelf production licenses, and both were a party to a joint operating agreement together with a third participant. And one of the license areas, despite being in the North Sea, was known as Val d'Isère. Now, at the same time, the price, or at least as part of the price payable by EEL under the farm-out agreement, EEL agreed to pay a percentage of Apache's quote-unquote total costs, including the costs of drilling an exploration well in the Val d'Isère area. Now, for the purposes of drilling that well, Apache used a drilling rig that was the subject of a long-term lease and whose cost was significantly in excess of the then market rate. I expect many of you are familiar with drilling contracts, which are often for the drilling of more than one well. Now, the issue was whether EEL had to pay a percentage of the total cost of the drilling rig, or whether that cost was effectively capped by the market rate. And one of the problems was that the expression total cost used in the farm-out agreement was not defined. Now, as many of you will know, joint operating agreements include detailed accounting principles that govern the allocation of costs between participants. And that allocation is usually governed by a fundamental principle that the operator will neither gain or suffer a loss as a result of acting as operator. And they are usually governed by a requirement that the accounting procedure will be fair and equitable as regards what is charged to the joint account and the apportionment of those costs between the various participants. Now, to cut a long story short, the Court of Appeal held that the words total cost in the farm-out agreement meant costs determined in accordance with the accounting procedure that was set out in the joint operating agreement. And that meant that there was a market rates cap on what Apache could charge for the supply of the rig. Now, one of the features of the case, and which is on the slide that I've got up at the moment, concerned the operation of inconsistency or priority clauses, by which I mean a clause that provided that in the event of a conflict between the provisions of the farm-out agreement and those of the joint operating agreement, the provisions of the farm-out agreement would prevail. And part of Lord Justice Carr's judgment deals with this, and she made it very clear that when dealing with that type of problem, the court needed first to decide whether or not there was a conflict between 2 different clauses, whether or not they genuinely were inconsistent. And she held that it's not enough that a term qualifies or modifies the effect of another. To be inconsistent, a term must contradict another term or be in conflict with it, such that effect cannot be fairly given to both clauses or the clauses cannot sensibly be read together. Now, very briefly, I think there are 2 points worth mentioning in relation to the exercise of contract interpretation that Lord Justice Carr undertook. Firstly, it's worth noting that she rejected Apache's submission that the farm out agreement and the joint operating agreement were to be treated as entirely separate contracts. And secondly, she held that her conclusions were, and I quote her here, reinforced rather than driven by the fact that EEL's construction was not in any way implausible or unworkable. On the other hand, she took the view that Apache's construction would have led to a somewhat uncommercial proposition for EEL because it would have created an open-ended exposure for EEL to cover a percentage of whatever costs Apache chose to incur. So again, what's interesting about this judgment is that you can see how at the end of the exercise of construction, of contract construction, being a unitary exercise, that the last topic or the last factor that's taken into account is how the construction works in practice and in commercial terms. Now, Apache were very busy in terms of litigation last year because the first of the first instance decisions is another Apache case, this time Apache against INEOS. Now, on this occasion, Apache were a little bit more successful than they were in front of the Court of Appeal. This is a case that's concerned with an agreement, again, for the transportation and, in this instance, processing of hydrocarbons produced from Apache's interests in the Forties field in the North Sea, and the transportation of those hydrocarbons through the Forties pipeline, which is owned and operated by INEOS. Now, in this instance, in this case, Apache wished to increase their estimated production profile for the period from January 2021 until December 2040. And they wanted to do that under an attachment known as Attachment F to the agreement. Now, the agreement permitted Apache to amend Attachment F, subject to there being some uncommitted capacity in the pipeline. But it went on to provide that INEOS shall not unreasonably withhold its consent, to such an increase. Now, INEOS stated that they were willing to consent to the amendment, but only if Apache agreed to a revised base tariff. Now, the preliminary issue, the subject of the judgment, was originally framed in terms of whether or not INEOS were acting unreasonably by withholding their consent to the amendment. But the judge rephrased the issue to ask this, whether INEOS were acting unreasonably and or non-contractually by withholding their consent, subject to Apache agreeing to pay a higher tariff. Now, it was INEOS's case that the amendment to Apache's production profile would increase the quantity of the oil that was going to need to be transported by some 120 million barrels, and that in part as a result, INEOS were going to have to invest very significant sums to extend the line. It was also their case that the base tariff, which I think was 60p a barrel, had been based on costs of the pipeline up to 2020 and not beyond. Now, it was Mr. Justice Foxton who dealt with the matter, and he approached the agreement with a view to determining whether INEOS had assumed the risk of having to continue to operate the pipeline beyond 2020 in return for the contractual tariff, or whether the TPA allowed the price of the original bargain to be revisited. And he subjected the agreement to a really detailed textual analysis, including a detailed analysis of the termination provisions. and he concluded that the TPA was a life of field agreement. So it was not limited to applying to the supply or the transportation, I should say, of hydrocarbons until 2020. So as a result, it was non-contractual in Mr. Justice Foxton's judgment for INEOS to impose conditions on agreeing to transport hydrocarbons post-2020. And effectively, INEOS's case was blocked by interpretation of the contract as opposed to looser considerations of whether or not it was reasonable for them to withhold their consent subject to Apache agreeing to pay a higher tariff. Now, that's a pretty harsh stance, I suspect, from where INEOS are sitting, and I would have thought that the chances are that we have not heard the last of that particular case. The next case I'm going to touch on only very briefly, but is the TAQA, Bratani and Rockrose case. And the reason I'm only going to touch on it briefly is because I know Paul is going to speak to the case in the context of his talk on good faith obligations. It's an interesting case because it's concerned with the removal of Rockrose as operator under a number of joint operating agreements. It's also interesting for those of us, I think, who practice in this area, because it's not the first time that TAQA and Rockrose have been parties to a case before the courts in recent times. Some of you may recall the Spirit Energy and TAQA against Marathon Oil case in 2019, when the Court of Appeal held that on proper construction of a joint operating agreement, the operator was entitled to require the participants to pay their share, their appropriate share of a pension deficit. Anyway, Rockrose was Marathon Oil. And so effectively, the second case, the TAQA Rockrose case, is all about TAQA's desire to remove Rockrose as operator. In short, on the facts, in June 2019, the claimants voted unanimously to terminate Rockrose's appointment as operator. The relevant clause of the contract simply provided that the operator may be discharged at the end of any calendar month by the operating committee giving not less than 90 days notice. So very straightforward. And the judge held that that was an unqualified right to terminate the appointment. The various arguments that were put forward, I will leave to Paul to deal with. But at the end of the day, when it comes to contract interpretation, the judge was very clear. The language was clear and unambiguous. Now, moving on, the fifth and last case is the wind farm case. So this is the Gwynt Ofto PLC case against Gwynt offshore wind farm. Now, whilst this is a first instance decision, it is the judgment of Lord Justice Phillips, and it's certainly worth again reading in order to absorb that practical application of the principles of contract construction. In short, the case concerned the interpretation of an indemnity provision in a sale and purchase agreement because the claimant bought the business of the defendant's business of owning, maintaining and operating the electrical transmission link between the wind farm and the national grid. And two of the export cables failed. One of them within days of completion of the transaction as a result of long-term corrosion. And what the claimant sought to do was to rely on an indemnity in the SPA by which the defendant had agreed to indemnify the claimant if any assets are destroyed or damaged prior to completion. You can see the terminology at the bottom of the slide. And so everything turned on whether the period that was contemplated by the words prior to completion meant at any time prior to completion, or whether it was limited to damage that was incurred in the period between the signing of the SPA and completion. And as I say, the court is another good example of how the courts will undertake a textual analysis of the relevant provision. And you can see briefly on the next slide how the judge concentrated on the tense that was used in the language. You can see here in the first bullet point of the slide that since the share purchase agreement was to be interpreted at the date it came into force, the natural and ordinary meaning of the phrase, if any of the assets are destroyed or damaged prior to completion, meant damage that occurred after execution of the share purchase agreement. Otherwise, it would have said something like, if the assets have been damaged prior to completion. Now, very briefly, because I know that my time is running out, what conclusions can we draw from the case law? I think there are a number of points that can be made. The application of the principles of contract construction are relatively, or the principles themselves, I should say, are relatively easy to set out. We can all quote, paragraph 15 from Lord Neuberger's judgment in Arnold and Britain. But what's much more difficult is to actually undertake the practical exercise when you're faced with a particular case, whether that's because you're giving advice or you're making a decision on what a particular provision means. Now, most of the energy and oil and gas contracts are obviously negotiated between experienced commercial parties and their lawyers, and the result of that is that less weight may well be given to certain aspects of the wider context. In fact, there are even cases that you read where, frankly, the factual matrix is regarded as not adding anything to the exercise. The language, that is the wording of any provision, remains the key starting point, and the court, it's quite clear that the courts will engage in a very detailed textual analysis. And then at the same time, I think it's worth making the point that commercial common sense continues to play a key supporting role. And you can see that in the Gwynt case. You can see that certainly in the Katz case as well. And then another point that falls to be made in light of the Apache and Euroil case is that the court is not going to be afraid of construing one agreement in the context or by reference to another. The last principle I had on the slide is that one can see from the case law, and in particular the Rockrose case, that the courts continue to be slow to imply terms, for instance, of good faith to limit termination rights. But that is a subject on which I'm going to hand over to Paul, although I think that Robert actually is going to introduce Paul.
Well, thank you very much, Veronique, for a very helpful and engaging talk from which we can take away lots of useful information. Now we move to Paul Buckingham. And Paul is a very unusual person because he's dual qualified. He's a very experienced barrister. You will hear about him having been in a leading Supreme Court case recently on renewable energy. And he's also a very experienced oil and gas engineer. He was a chemical engineer with BP for 8 years, doing design, construction, and commissioning on oil and gas projects. So that's his background, and of course, that's what his practice is, complex technical disputes, particularly in this field. I mentioned he'd been in this leading case, and many of you will know the MT Hogarth and E.ON case from 2017, where Paul was on the winning side in a big dispute about an offshore wind farm. So he certainly made his mark in this field. And as an engineer, he continues to be very involved in the Institution of Chemical Engineers. He's a fellow, he's on their contract committee, and he's the chairman of their dispute resolution committee drafting and administering its dispute rules. So you really can't do better for hands-on oil and gas advice than Paul Buckingham, and I now hand over to him.
Okay, thank you, Robert. I will just attempt to share the correct screen. So I hope you all got the slides up. So yes, good afternoon, everyone. I'm talking about good faith obligations and energy contracts, and I'm going to divide my talk up into 4 sections. The first one is a brief introduction to the different categories of good faith obligations with which the courts have been grappling recently. And then I'm going to look at 3 particular cases. The first one is the TAQA Bratani case that Veronique has touched upon. Then I'm going to look at a PFI construction contract. That was a decision of the Technology and Construction Court. And then finish off by looking at a commercial contract, and that's a decision in the Chancery Division. So just by way of background, a quick update on where we think the law is on good faith obligations prior to these 3 cases from last year. So in terms of implied good faith obligations, the first one that parties normally put forward is effectively a term restricting the exercise of a contractual discretion, and that's what's commonly called a Braganza duty. And these tend to arise where one party has a contractual power or discretion. And it's important there to note it's a contractual power or discretion rather than necessarily an option. And in those circumstances, the law may well imply a term that the party, first of all, would exercise the power or discretion in good faith, and secondly, would not act arbitrarily, capriciously, or irrationally. And the background for that is well founded in authority, and the reason it's called the Braganza duty because it stems from what Baroness Hale said in the Supreme Court case of Braganza and BP Shipping. And in that case, Baroness Hale said that a party who is charged with making decisions which affect the rights of both parties to a contract has a clear conflict of interest. That conflict is heightened where there is a significant imbalance of power between the contracting parties, as there often will be in an employment contract. The courts have therefore sought to ensure that such contractual powers are not abused. They have done so by implying a term as to the manner in which such powers may be exercised, a term which may vary according to the terms of the contract and the context in which the decision-making power is given. So this sort of term is well founded, and it's immediately apparent that this imports what I would call public law principles into a commercial contract by reference to the capricious and irrationality provisions. And that was also recognised by Baroness Hale, who said there is an obvious parallel between cases where a contract assigns a decision-making function to one of the parties and cases where a statute or royal prerogative assigns a decision-making function to a public authority. In neither case is the court the primary decision maker. The primary decision maker is the contracting party or the public authority. It is right, therefore, that the standard of review generally adopted by the courts of the decisions of a contracting party should be no more demanding than the standard of review adopted in the judicial review of administrative action. The question is whether it should be any less demanding. So this is where a party has a power or discretion, and it's placing some limits on that power or discretion. The second type of good faith obligation which parties attempt to apply into contracts is a more general obligation of good faith. And these are said to arise in the context of what are called relational contracts. And this all really started off with Mr. Justice Leggett in a case called Yam Seng. And he defined in that case relational contracts as those governing long-term relationships to which the parties make a substantial commitment. Now, that definition was refined further by Mr. Justice Fraser in the case of Bates and the Post Office, in which he identified 9 factors which might indicate the presence of a relational contract. And I'll have a look at those 9 factors shortly when I go through the 3 cases from last year. Now, if a relational contract does exist, then the law may imply a term requiring the parties to deal with each other in good faith. But the word may is important there because it's not necessarily the case that there will be an implied term just because a contract is a relational contract. And Mr. Justice Leggett, as he then was, said in Yam Seng, such relational contracts may require a high degree of communication, cooperation and predictable performance based on mutual trust and confidence, and involve expectations of loyalty which are not legislated for in the express terms of the contract, but are implicit in the parties' understanding and necessary to give business efficacy to the arrangements. And he gave examples of relational contracts, including joint venture agreements, franchise agreements, and long-term distributorship agreements. So the key point there is the express terms of the contract don't legislate for every single scenario, but it's implicit and necessary to give business efficacy that there's an implied obligation of good faith. So those are the 2 categories of good faith obligation. And I'm now going to move to 3 cases and see how those particular disputes applied or didn't apply good faith obligation. So the first case is the decision in TAQA Bratani, which Veronique has touched upon, and this arose out of joint operating agreements regulating the operation of 5 oil and gas blocks known as the Bray fields in the North Sea. And TAQA sought declarations that it had validly terminated Rockrose's role as operator of the fields under those joint operating agreements. And in response, Rockrose argued, and amongst a number of arguments, that the termination rights were qualified by obligations that required TAQA not to exercise those powers capriciously, arbitrarily, and only in good faith. So that's both the Braganza duty and the general duty of good faith. Dealing with those in turn, the judge rejected the notion that there was a Braganza duty. And he said, I consider it clear that on the current state of the authorities, the Braganza doctrine has no application to unqualified termination provisions within expertly drawn complex commercial agreements between sophisticated commercial parties such as those in this case. What he actually said was that where parties make a provision that entitles one or more of them to terminate the agreement, the clause should take effect within its terms. In other words, his view was that the parties should be held to their contract and to the terms of the contract. And he went on to say at paragraph 53 that absolute rights conferred by a professionally drawn or standard form contracts are an everyday feature of the contracts that govern commercial relationships, and extending Braganza to such provisions would be an unwarranted interference in the freedom of parties to contract on the terms they choose. So it's clear from the tenor of the judgment of His Honour Judge Pelling QC that he thinks that the contract is king and that the parties should be able to draft the contracts they want, and that the law shouldn't interfere with those by implying additional terms that qualify those particular rights and obligations. Now, there was a subsidiary point, and this related to the fact that the termination right in this case only terminated one party's role as operator rather than terminating the contract as a whole. And the question was whether that made any difference to the principles being applied. And the judge dispatched that argument in fairly forthright terms. He said that there was no reason to treat a provision which brings the relationship of the parties to an end differently from one that entitles one party to terminate a particular role carried out by one of the parties. And he said, even if such a distinction does have a principal basis, in my judgment, that does not lead to the conclusion that a Braganza term should be implied, because to imply such a term would depart from the cardinal rule that, inverted commas, if a contract makes express provision in almost unrestricted language, it is impossible in the same breath to imply into that contract a restriction that qualifies what the parties have agreed should be unqualified. Again, holding the parties to the contract is the position that the judge was coming from. Having dispatched with the Braganza duty, he then looked at the general obligation of good faith and whether that could be implied into the contract. Now, in this regard, the judge was content to treat the joint operating agreements as a relational contract, so we didn't analyse the particular criteria of Mr. Justice Fraser. He proceeded on the basis that they were relational contracts, but having done that, he then said, well, it wasn't necessary to imply an obligation of good faith into those contracts, and he did so for three real reasons. First of all, he said that the power to terminate is an absolute and unqualified power, therefore it essentially didn't need qualification. He thought it was impermissible to imply a term that qualifies what the parties have agreed. In other words, the parties agreed a term in the contract, they should be held to that term in the contract. And he said that the parties have legislated their obligations in the express terms, and it would be wrong to imply a term to qualify that power. Again, a strong reference to the contractual terms having been agreed, and therefore leaving little room for additional implied terms. And the final point to note in that case was that there was an argument run that industry practice supported the implication of such a term, and the judge decided that there was no such industry practice. So in the TAQA case, no Braganza duty, no general obligation of good faith, and therefore TAQA was entitled to exercise that contractual right of termination effectively as it saw fit by applying the terms of the contract. So that was an energy decision from January of last year. Move forward several months to the summer, and we then have the decision in the Essex County Council and Beza Balfour Beatty case. And this matter concerned a 25-year PFI contract under which UBB was to design, construct and operate a mechanical and biological waste treatment plant in Basildon. And the purpose of this plant was to process Essex County Council's waste. And the main output stream from this facility was something called SRF, which is solid residual fuel. And that was then exported to be used by other parties to generate power. And there are a number of issues in dispute in this case. They're all mainly related to the design and construction of the plant and whether there was a defect there. In fact, the court held that there was a defect, and this all stemmed from an error in a density calculation that meant the facility was effectively half the size it should have been, and therefore could only process half the waste that it should have been capable of processing. The particular point we're interested in is the scope of a termination right that accrued to Essex County Council and the circumstances in which it could exercise that termination right. Again, UBB argued that there should be a Braganza duty in there. And dealing with that point, Mr. Justice Pepperell said that he would readily imply a term requiring contractual discretion to be exercised rationally and in good faith. But that's a contractual discretion. In terms of the termination right, he said that there was no scope for the term where a party is exercising an absolute contractual right. So he drew the distinction there between the exercise of a contractual discretion, and therefore the duty would apply. But if it was an absolute contractual right, the Braganza duty didn't apply to that. And he said that a contractual right to terminate is not generally subject to any qualification of good faith. And he agreed with the observations of Richard Salter QC in the case of Mond Petroleum, where he said it's unlikely that the hypothetical reasonable commercial man or woman would expect the party exercising that right to be obliged to consult anyone interests but their own. And you can see the logic for that in a termination provision. One party, the party exercising that termination right, is going to look to his own interests first. So having dealt with the Braganza point, Mr. Justice Pepperell then went on to consider whether this particular contract was a relational contract. And in deciding that, he considered that Mr. Justice Fraser's factors that had been identified in the Bates case were helpful indicia, but weren't to be applied rigidly like the words of a statute. So he then looked at those indicia and concluded as follows. And you can see from the first bullet point there, he considered that there were no inconsistent terms in the PFI contract. Interestingly, in doing so, he considered that a sole remedy clause was not inconsistent with the implication of terms, nor was an entire agreement clause. He then went through 6 other factors which are listed there, which he said pointed towards it being a relational contract. Now, just pausing there for a moment, if you look at the judgment, in reaching those conclusions, the judge did so in very short order without any particular discussion. He just listed those as the particular factors that he had decided were present. And therefore, he reached the conclusion that it wasn't a relational contract. And at 113, he said, standing back from the 9 factors identified by Mr. Justice Fraser, I conclude that this 25-year PFA contract is a paradigm example of a relational contract in which the law implies a duty of good faith. So the judge in that case did imply an overarching duty of good faith into the contract on the basis that it was a relational contract. Now, in terms of the content of that implied term, the judge said this. First, whether a party has not acted in good faith is an objective test. Perhaps no surprises there, but it's an objective test that one applies. He said, dishonest conduct will be a breach of the duty of good faith, but dishonesty is not of itself a necessary ingredient of an allegation of breach. And that's quite an important decision. So, of course, whilst bad faith would be a breach of that obligation, it's not a necessary prerequisite. The threshold test is whether it's commercially unacceptable conduct. And of course, that can be context specific, as he recognised in point 3. What will be required in any individual case will depend upon the contractual and factual context. So there is some help in that judgment and some light on what the content of that term of good faith would be, but because it's contractually and factually contextual, you can only draw conclusions in relation to a PFI contract for a waste treatment plant. So the final case I was going to look at is the Cathay Pacific Lufthansa case, and that was from the summer of last year. And this matter concerned a 10-year maintenance contract between Cathay Pacific Airways and Lufthansa for 27 Pratt & Whitney PW4062A jet engines, and that should be a picture of those particular engines, which were deployed on a fleet of 6 Boeing 747-400 freighter aircraft. And at the expiry of the 10-year term, there was a payment dispute which centred upon reconciliation payments, which resulted from Cathay Pacific's exercise of an option to remove some of the engines from the service programme. And the question of whether they could or could not be removed then dictated the payments that became payable. And the question that the court had to deal with was whether that removal right was qualified either by interpretation of the express terms of the contract or by the implied terms. Now, in terms of the express terms of the contract, the judge decided there was no ambiguity in the contract language that would cause him to interpret the clause differently. So he then went on to consider the scope for implied terms into the contract. In terms of the Braganza duty, he summarised the principles as follows: not applicable to every contractual power or discretion. It was applicable to decisions affecting rights of both parties where the decision maker has a conflict of interest. That's echoing the words of Baroness Hale. The nature of the relationship and the balance of powers are factors to consider, and the scope of the term will vary according to the circumstances and terms of the contract. And he concluded that there was no Braganza duty to be implied as a fetter on the exercise of that contractual option. He said that the power of a party to withdraw an object from a contract of service is inserted for the benefit of the withdrawing party, and therefore it ought to take effect in accordance with its terms. And he said the option was closely analogous to that partial termination clause that we saw earlier in the TAQA case, and far closer to the sorts of cases which have previously been held not to be the subject of a Braganza duty. And he pointed out that it was worth remembering that the Braganza line of cases are exceptions to the general principles that have been previously set out, in particular by Lord Reed in the White and Carter case, in which he said, to quote, "It has never been the law that a person is only entitled to enforce his contractual rights in a reasonable way, and that a court will not support an attempt to enforce them in an unreasonable way." So taking a step back, the contract says what it says and the parties are held to the contract. In terms of the general obligation of good faith, the judge, John Kimball QC, summarised the present state of the law as set out on that slide. Only imply subject to a contra express term. He said the term may be implied as a matter of law where future collaboration is required in ways that have not been specified. Term may be implied as a matter of fact, but there's no special rules and each term must be considered against the usual test. And in his view, the primary test is whether the term is so obvious that it goes without saying or that it is necessary for business efficacy. And that's actually really not any new principle. It's simply a restatement of the general law of implied terms. And he also thought that the characteristics in Bates were helpful indicia. Now, applying those principles to this particular case, he rejected the implied term as a matter of law. He said the only relevant criteria was it was a long-term contract, but it plainly wasn't a joint venture. And in fact, there was a term in the particular contract that expressly said that it wasn't a partnership or a joint venture. And he focused on what was actually being required by the contract. And it was a contract to service engines rather than a contract regulating a relationship between the parties. And he said that made it the polar opposite of a relational contract because there was an ability to subcontract some of the services. So he dispatched the implication of a term as a matter of law. He then looked at whether it can be implied as a matter of fact, and he was impressed by the fact that it was a detailed contract drafted by commercial car parties. Again, at its core, a contract for engine maintenance services rather than one regulating a relationship between the parties. Not essentially collaborative. The risk and reward was carefully balanced. It was to a large extent impersonal. And that as a genus of contracts, engine maintenance is not an obvious candidate for an implied term of good faith. And he also pointed out that there were some express references to good faith in specific areas of the contract. So didn't imply it as a matter of fact. The final criteria looked at was against the Bates indicia, and he concluded that it was not a relational contract. And he referred to the fact that while some of the elements set out in Bates were present, such as exclusivity, cooperation and long duration, he didn't think they were sufficient to warrant the agreement being classified as a relational contract. And in particular, he considered that there were two core indicia, numbers 5 and 6. And these are the ones, number 5, the spirits and objectives of their venture may not be capable of being expressed exhaustively in a written contract. And 6, they will each repose trust and confidence in one another, but of a different kind to that involved in fiduciary relationships. And the judge thought those were two particular core factors and that they weren't satisfied in this case. So he then concluded that it wasn't a relational contract and therefore there was no general obligation of good faith. So what can we conclude from those three cases? Well, my final slide, I have a few concluding remarks. I think, first of all, it's well established that a Braganza duty can be implied into contracts, but it's unlikely to fetter an absolute contractual right. In terms of the wider obligation of good faith, well, the overall character of the contract is important. A long-term contract requiring cooperation is not enough. There are many commercial contracts that are long-term and many commercial contracts that require cooperation, but you need something more. So the requirement for trust and confidence must go beyond that normally found in a commercial relationship. Nonetheless, it does appear that PFI contracts are certainly amenable to the implied term. We saw that in the Essex and UBB case. But the final point to note is that this is still a developing area of the law, and I think this represents the current position, and we'll see how things develop in 2021. So with that, I'll stop sharing and I think hand back to Robert, who's going to have Sean as the next speaker.
Thank you very much, Paul, for that very enlightening exposition on good faith. And that then takes us to Sean Wilken QC, and he's got an amazingly wide energy and oil and gas experience. It's wide not only in the geographical sense, he's acted in Australasia, Southeast Asia, Central Asia, India, Africa, Russia, the North Sea, North and South America, and even the Arctic. But it's also wide in the sense of the subject matter. He has dealt with all the conventional energy and oil and gas issues, but lots of nuclear, lots of security, and he's got very wide experience as regards the parties involved. He's acted for governments, for majors, miners, for contractors, for people concerned with sanctions aspects, and so on. So Sean is going to be telling us about future trends, and there's no one better than him to address that issue, given this incredibly wide experience that he's got. So over to Sean.
Thank you very much. Like everyone else, I will endeavour to share my slides. There we go. So I will be talking about future trends in energy claims. I'm conscious that this involves a degree of speculation and crystal ball gazing. Indeed, when I started thinking about this talk, I realised that I'm old enough to remember both the energy crises where there was scarcity of resource, the peak oil debate in the 1970s, and then of course the collapse of the petrodollar in 1973. I'm also old enough to remember when scarcity of demand became a problem. See the oil price crashes in 85, 2008, 2014, and 2012. We've also seen the toing and froing in geopolitics. So you've had the debates between OPEC and America in the 70s. These days, we have the debates between OPEC and OPEC Plus, where you have the debate about whether production should be increased or decreased, the debate between cuts versus income. And one can look at this as closely as OPEC resolutions in March 2020, which was to not to cut revenue and not to cut production, versus January 21, which was to slightly reduce production. And then, of course, you've got the persistent role of national oil companies, majors and miners. So there is a degree here of plus ça change, plus la même chose. And indeed, in this talk, what I'm going to be picking out are themes. I'm not going to be addressing the perennial problem which arises in energy projects, that they're complicated, expensive. They involve groundbreaking kit in difficult situations with chemicals that are likely to explode and or corrode. And so I'm not going to be addressing, if you like, the repeat players that we will see in terms of refineries failing or pipelines failing or complicated drilling equipment failing. These are more general themes. So I'm going to start with ones that we can see on the horizon, and as we go along, we're going to look further and further out. First one, obviously, is SARS-CoV-2. The interesting thing globally is you have very different reactions to the pandemic. You have what I call the laissez-faire populist model, which is UK, US, Brazil, Sweden. You have the repeated strictly enforced lockdowns, France and Spain. And then you have rigorous isolation and track and chase, see New Zealand, South Korea and Japan. We also have differing legal reactions as well. So China immediately issued force majeure certificates to all affected industries. At the other end of the spectrum, you have the extensive use of non-binding guidance or devolution to individual states. We've also seen the position change over time globally. So in all cases, we have to look at what the position was in any given country, or indeed globally, if you're talking about a global supply chain, before you come to any analysis as to the effect of that position. In England, being parochial for a moment, the response has been very confusing. It's not just me who says that, there are others who've gone into print on it. And it's been more difficult about the whole way, it's been made more difficult by the whole way the procedure has been gone about. What does this mean in terms of claims? Well, You've got differing nations adopting differing regulatory approaches. That has an impact because obviously if you have a nation completely clamping down, that can affect supply chains or your ability to perform in that nation. B, obviously courts of civil law nations where they have established doctrine of force majeure have more freedom to try and tailor the case to the appropriate outcome, or tailor their result to reach the appropriate outcome. And we've seen this again in the more interventionist approach in the PRC, where PRC regarded SARS, for example, as an FM event, and there was an early declaration by the Ministry of Housing that SARS-CoV-2 was an FM event. In the common law courts, we're obviously tied to the words of the contract because there's no established doctrine of force majeure. What does this mean in the energy context? Well, unfortunately, the standard contract wordings are unhelpful. So your joint operating agreement, AIPN standard wording, mirrors the upstream contract. So in other words, you import into the JOA any local law issues in relation to FM. The logic wording for the North Sea includes change in law. So force majeure will include a change in law, and we are already seeing arguments about whether what has happened in England and Wales and Scotland has amounted to a change in law. Beach, there you must prevent the supply of gas, very difficult to establish. And then by way of comparison, the Hong Kong terms, you have, and these reflect FIDIC, etc. You have a possible EOT only, and obviously a claim for monies is more difficult, and the HKIA is in similar terms. One glimpse of hope on standard wordings: if you have a material adverse change provision in the suite of contracts, that may assist, because I think there is a lot of traction, particularly in underlying financial arrangements, to say that COVID represents material adverse change. The second main future trend is the low oil price. So having checked this afternoon, Brent crude is at 55.44 per barrel. OPEC basket is at 54.85. Obviously, that's not as low as it was in 1985, but compared to the peak in the last 10 years, it's half what it was. What does that mean? Well, this seems unlikely to change. A survey of major explorers and producers said that they were carrying out their current upstream capital expenditure predictions based on $44 per barrel. This may well make deep water exploration and production unprofitable. So what are the results of those two in perhaps the near to mid future? It seems to me that you've got four types of claims that might be coming down the pipe, if you pardon the pun. Force majeure frustration, cash call disputes, decommissioning disputes, and production and exploration slowdown disputes. Turning to the first of those, frustration. It's going to be very difficult to launch a frustration claim. It seems to me probably almost impossible without some pretty serious unusual event and some very unusual facts to back this up. So we're going to be looking at force majeure. Putting on my common law hat stroke viewing glass, it all turns on the clause. It seems to me, and I hope I'm right, that some of the standard wordings might apply. Obviously, if you've got epidemic pandemic, that will work. Arguably, plague may work. We all think of plague as the Black Death. However, the English cases don't. And you have to go back to the 17th century here. They regard plague in general terms as just a bad outbreak of local disease. Act of God is definitely possible. And restraint of princes, where you have lockdowns, those seem to me to be equivalent to blockades. So you might get into the standard wording, but causation will be very difficult. See Seadrill and Tullow, an oil and gas case, which I'll come back to. But note, there may be some hope in some of the wordings. If you have impacted by, that's a better wording for you if you wish to claim than sole cause. And if you have hinder, again, that's a better wording than prevent, because prevent means prevent. Here I turn to not localized force majeure, but the supply chain. Now, originally, I was a skeptic on force majeure and supply chain, and I'll explain why, but here's the outline. The AIPN applies force majeure as it stands up the contractual chain. Therefore, you have to look at the local law PSA to determine what is and what is not force majeure. And that may give complications, may give rise to complications where the local law and the law of the seat of the arbitration conflict. That's an aside from a position where, say, local content may cause the seat of any arbitration to have to be resolved in what might be termed a tricky part of the world in terms of COVID. In terms of unpacking that, force majeure and supply chain, I said originally I was a skeptic, but given the pulsed nature of this epidemic and given the long-term impact on solvency, it seems to me increasingly possible that a force majeure and supply chain claim could stand up. Second head of claim, cash call disputes. For those who were involved in the litigation after 2008 and 2014, you will have seen this before. As cash flow reduces, parties will regret decisions made previously. They will therefore seek to challenge previous vote by notices, or VBNs, to unpack those provisions for those who don't do a lot of JOA work. What happens is the parties to the JOA are polled. They have what's known as a vote by notice, and they tick a box saying yes or no. I have had cases where parties have ticked yes and then tried to argue that yes, in fact, meant no. There may also be accounting provisions challenges, again in JOAs. These are the ways by which expenditure is approved and then paid for. And again, you will have a time lag between approval and then payment. And if there's a crash in the market between the two, you will see people try to avoid payment. Similarly, you have associated buyer's remorse on farm-ins and farm-outs. Veronique explained what those were. And so you have people trying to unstitch those. And in extremis, they will raise what are called root and part claims, which are claims for bargaining their way out of the FOA or FIA. What we are seeing in decommissioning disputes are a number of points. First, parties are simply not paying charter party rates during decommissioning. If you think about it, there's little upside to decommissioning. The rig is standing there idle, you can't use it, so therefore why pay if you don't have to? What we're also seeing, certainly in Scotland, is that the decommissioning ports are full. So if you look at Invergordon at present, Invergordon has no space, therefore people have got to sail around the top of Scotland to the west coast. Where you are dealing with semi-submersible drilling rigs or FSPOs, there may well not be a further charter party, so you won't simply be preparing them for another job, you'll be laying them up or indeed engaging in stacking or rig recycling. We have similar issues, namely in terms of buyer's remorse in relation to production and exploration. Again, for those who don't deal with production sharing arrangements, they have arrangements as to the phases and commitments of both exploration and production. In collapsing oil prices, people begin to wish they hadn't entered into those, particularly exploration, which is expensive, and so you can see debates over that. Similarly, you have the scaled down use of rigs and FSPOs, which will trigger charter party disputes. Then take and or pay disputes. We saw those back in the mid-90s, again in 2010, where in a good time, a party has agreed an obligation to take and pay for a specific amount of gas or oil, or take or pay for a specific amount of gas or oil at a particular price. As the oil price changes, people wish to escape that. And of course, if you have a squeeze upstream, where you then have downstream supply lines where people have said, well, I will supply so much oil or gas to you at the following amount. One can see the knock on there. Other future trends, Brexit. This is one purely for the gas and oil traders. We do have an FTA, but what it's done is gone, oh, that's a difficult question, and kicked it down the line. So at present, most is all in limbo because there will be a new arrangement at some point. And then I set out there the items that are in limbo and what people involved in the market may have to think about. Renewables. We see two categories of claims currently, contractual and defects. And those form fairly standard elements, namely contractual, what am I supposed to supply in terms of kit, or what am I supposed to supply in terms of output of my renewable resource? And then of course defects. The wind turbine doesn't work, the solar furnace doesn't work, it cannot achieve the output that we have guaranteed elsewhere. And those are proceeding fairly normally, albeit in a newer context of renewables. There are, it seems to me, a couple of future unknowns, says he, having a Rumsfeld moment. One is what will be the future regulatory regime. I think that is going to be interesting. There is obviously a Brexit factor. There is levelling up, levelling down. So I think that could be very interesting. And then at present, there is a glut of capital out there wishing to invest in renewables. And so a lot of deals have been done that perhaps in retrospect may seem to be a little unwise. And so one will see those beginning to unstitch. I've got one at present, which is an arbitration where a large investment was made in a solar furnace, and both parties now wish to find an alternate means of getting out of it. So both are alleging that the other have been very, very naughty indeed, including fraud, money laundering, etc., etc. The next, slightly more speculative one is climate change litigation. This is an increasing trend. For the academics that have studied it, they have located 26 new cases worldwide. Outside the US, there are much larger number of cases in the US in the last year. And these can be broken down into a number of types of challenge that have been seen. So you have challenges to high emission projects, power stations, etc. Challenges to carbon pricing schemes, regulatory challenges to projects. So, for example, there have been successful challenges to projects on the basis that they haven't taken account or proper account of the environmental impact or the effect on particular protected areas. And then you also have the more, if you like, tendentious end of the market where you have focused attacks on the carbon majors. I think what we may see, and we have seen in the past, is the use of class actions in the English courts. Here, obviously, I'm going to cite myself twice on this page, but hey, you know, silks are allowed to do that. You have Motor and Trafficura, which is an early example of a class action back in 2007 through to 2010. And then you have the Municipio de Miriana against BHP in the autumn/winter of last year, where a large class action spectacularly collapsed before the English courts. So you have the two ends of the spectrum there. You also are seeing, what is interesting, the use of human rights and soft law. So if you are in the Netherlands, the risk of climate change falls within the ECHR Articles 2 and 8, which is interesting. So the courts there have held that if there is climate change, then the ECHR may be in play. And we are seeing that even in arbitration. An article on Keating Update about this, where we've seen it used in the context of water rights cases. Last topic is international law, the UN Convention on the Law of the Sea. Bear with me on this one. So we have maritime boundaries in the context of oil or gas causing friction worldwide. So you have China and the 9 dash line in the South China Sea. You have Russia and its submarine planting a flag on the Montsalv Ridge to claim territory. And even in states that you think would normally be friendly, US and Canada, we see frictions there. It's a well-known apocryphal story that the Canadian Coast Guard had to appoint Coast Guards to go and pick US flags off bits of Canadian territory in the Northwest Passage because the US was hoping to acquire usual rights. We'll have a look at one closer to home to see how this might work out. In the Eastern Mediterranean, there are 12 maritime borders, of which 10 are disputed. All the littoral states are exploring: Israel, Egypt, and of the blocks on offer, 36% are contentious, and you have states that are actively in dispute. So you have a Greece-Turkey dispute, a Lebanon-Israel dispute. Then I'm going to take Cyprus. Cyprus is, of course, interesting because at present you have southern Cyprus is part of Greece and in the EU. Northern Cyprus is part of Turkey and not, and this is obviously quite a fractious area. But Cyprus's EEZ, Exclusive Economic Zone, alone contains 12 blocks. And we have some big plays, some big players, and some big discoveries and licenses here, and I set them out. Why does this matter? Well, I'll take 3 examples. The first is the ENI case, the second is Tullow, and the third is resource management of money. In ENI is an Italian company. They carried out exploration activities offshore Cyprus in waters disputed by Turkey. Turkey therefore retaliated by suspending all operations with ENI, including a large pipeline. Ghana, Cote d'Ivoire, this is Tullow. You there had oil fields in disputed waters. Cote d'Ivoire brings the first challenge for interim relief before the INEOS tribunal, which is a specially created tribunal created under UNCLOS. What the tribunal held was that Ghana could allow the shooting of seismic, but no new development, as that would permanently modify the environment and allow Ghana to contain valuable subsurface information. What was the impact of that? The problem. Ghana had already let blocks in the disputed area to a consortium of which Tullow was the operator. The production sharing agreement committed the consortium to further drilling, because it's only via further drilling that you can know that there are exploitable hydrocarbons. Tullow had 2 rigs engaged to carry out the drilling program. The INEOS order closed down the planned drilling program and led Ghana to reconsider the whole deep water development program. Tullow was exposed on the charter parties for the rigs, over $300 million. And of the 2 events, closure of planned drilling and reconsideration, one was force majeure, one was not. Tullow, whoops, omission of not here, was not able to rely on force majeure because of those 2 causes, and that's sea drill. And the irony of all that is the Cote d'Ivoire eventually lost the hearing before INEOS. So all of this was a very expensive storm in a teacup. So that is the risk. If one gets to resource management, the other side of this is, of course, it can stifle development where a major or a minor has invested in an assigned block. The exploration can be stopped. This means, of course, there's wasted cost and time. In deep water, that can be significant. And this can trigger, obviously, ICSID and other arbitrations. You're going to have both litigation and arbitration. I say that because charter parties, for example, can have English choice of law clauses, but your PSA and your JOA will, in all probability, contain an arbitration clause. You may be liable down the line to reparations. And of course, there's the law of unintended consequences, CAIEIN. But added on top of that, you can have problems with pipelines exporting out of an area. If the area is disputed and you have to go through one of the disputing countries, your pipeline may be blocked. And we've already seen issues with this over an Israeli pipeline, a Russian pipeline, and of course, Canada and Keystone. You may be subject to embargoes and or sanctions. So whilst UNCLOS may seem theoretical and existing at the level of international law, when it actually begins to be applied in real cases between real parties in terms of real money, it can have significant implications. Thank you very much for listening. That was something of a canter through. I will stop sharing my screen and we can all go back to chat.
Well, thank you very much, Sean. Very interesting, very helpful. And I believe that all the other speakers are now going to come back online so that we can look at one or two questions where we've got the opportunity to address those. And there's one which is clearly suited to Veronique. Which of the 5 cases would you read if you wanted to see the best instance of the practical application of the known principles of contract construction? Over to Veronique.
Quite a question. Well, I think that I would have to go for the Teesside judgment for Lord Justice Males, because whilst it is, as I said, turgid, I think it's an absolutely superb exposition of the exercise of contract construction, taking what is a very difficult contract and very difficult terms and actually making them seem very clear. So I think I would go with that one. I'm quite keen on the wind farm, though, on the Gwynt case as well. But I think I'd choose Teesside.
Right. Thank you very much, Veronique. And now one which looks right up the Paul Buckingham Street. Energy contracts are often very specific. Should good faith interpretations made by the court apply when the parties are clear on their understanding of the contract's meaning? Over to Paul.
Yes, well, I think the tenor from a lot of the recent cases is that the contract is king, and if the parties have got a very detailed set of provisions regulating the way in which they want their contract to operate, there's very little room to imply terms. It's very difficult for a bystander to stand there and go, well, it would, if you'd have passed the parties, it was obvious they wanted this or that in the contract, because you have a very thick contract that's been negotiated over a long period. And in fact, I was just looking back in the Cathay Pacific case, and the judge said in that the underlying rationale is clear. If the parties have specified with precision what they are obliged to do in particular circumstances, they are not, in respect of those matters or circumstances, trusting each other to act in good faith. The legitimate expectation that each has of the other is not that they will act in good faith, but that they will do what the contract stipulates they must do. So there's a clear steer there from the court that, well, if you enter into a detailed and complicated contract, you expect the contract stipulates what each party should do, without the risk of the law or the court implying all sorts of qualifications. So yes, I think there is, the more detailed an extent of the contract is, the less room there is for the implication of such terms.
Thank you, Paul. And now a high level one, but a very penetrating one, which looks like it's ideal for Sean. How would you suggest a student gets to grips with the application of law in energy and construction? Can you suggest a good place to start? Over to Sean.
That's a tough one. Because you have so many jurisdictions, sorry, excuse me, my dog is now seeking to assist on how one assists with learning the law in this area. Because you have so many jurisdictions, you always got to narrow down your jurisdiction. In terms of England and Wales, you're obviously looking at the North Sea, and there are some useful collations of work, of works and articles on the North Sea, which are useful to read into. Unfortunately, I don't have them to hand here. Otherwise, I could give you some citations. But if you look at, there's a recent textbook published in the last 2 years on energy law in the North Sea, and that's a very good primer for that area. Once you move out of that, then I'm afraid you're looking at things like the AIPN, which produce the standard terms, and they will govern most of the international work. And then obviously, if you're interested in international law, you'll be looking at things like Oppenheim on international law, and then into the more rarefied area of UNCLOS. So the answer is start local, start narrow, look at the North Sea and see the type of problems that are emerging there. And as I said, there are good works, usually in fact out of the University of Aberdeen, because that's where a lot of people who practice in this area, a lot of academics who practice in this area are based.
Thank you very much, Sean. And I think we've got time for just one last question. And this one seems to have all the requirements for a good question for Veronique. Did the decision in the Spirit Energy and TAQA against Marathon Oil case impact the decision in Rockrose?
The answer to that is yes, insofar as the judge was looking at the facts, and that's because Rockrose, as the operator, did argue that there was a collateral purpose in the decision of the other participants to remove it. That collateral purpose, as I recall, being to circumvent the decision of the Court of Appeal in the first case, in the Marathon case. So it was relevant as part of the underlying facts, but the judge held that in fact there was no evidence that that was part of TAQA's motivation.
Right. Thank you very much, Veronique. And thank you very much to all our panelists, because that's been an extremely helpful energy seminar that we've had. And for the attendees, if I can remind you again that this is part one of a two-part seminar. The second one is going to be in a month's time on the 24th of February. And what you've seen and heard today is all going to be available by the end of the week on our Keating Chambers website and also on YouTube. So you'll be able to see what you've seen today and make notes where you need to with less pressure than you've probably experienced today. Well, now that brings us to the end of our 1.5 hours, and I've been given strict instructions that we have to end on time, and we're going to be able to do that. So in conclusion, just to say thank you to all the attendees